A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under Lexis and Company, am here to present my topic, Doctrine of Res Gestae. So, Doctrine of Res Gestae has been mentioned under the Indian Criminal Code in the form of Section 6 of the Indian Evidence Act. So, let's understand what does Res Gestae mean. So, Section 6 says relevancy of facts forming part of the same transaction. So facts which though not are in issue are so connected with the fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different time and places. So res gestae originally was used by the Romans to mean acts done or actus. The English and American writers described it as facts that form the same transaction. Res gestae are those facts which automatically or naturally form a part of the same transaction. They are the acts talking for themselves. These facts become relevant due to their association with the main transaction, which itself is a relevant fact in the nature of issue. Now, let's talk about a case law important for the doctrine of res gestae. So today we shall be talking about case law of Saval Das versus State of Bihar, whose citations are All India Record 778 and SCR 374. This particular judgment was authored and was a one bench judgment which was authored by Justice M.H. Beck. So now let's understand the facts of this case. So the facts are that the appellant is the husband of the deceased, and the evidence in the case established that the relations between the deceased and her mother-in-law were very strained. That on the morning of the murder, following a quarrel between them, the appellant went with his wife, the deceased, into a room into which his father and mother then followed. That immediately thereafter, cries of the murdered woman were heard to save her from being killed, and that a little while later, the appellant and his father conveyed the dead body of the deceased and disposed it off by burning it without informing the relatives of the deceased who were living in town and without performing any funeral rites. So, on the basis of the facts and the evidence established, let's understand the verdict of the trial and the High Court. So, on this evidence, rejecting the appellant's contention that the deceased died accidentally of the injuries which were caused by fire, the trial court convicted the appellant, his father, and mother for offences under Section 302 and 34 of IPC. The trial court also convicted the appellant and his father under Section 201 of IPC. On appeal, the High Court acquitted them of the offence under Section 302 and Section 34 of IPC, but found the appellant alone guilty of the offence under Section 302 of IPC. The High Court also found the appellant and his father guilty under Section 201 of IPC and passed a sentence of 3 years against the father. No separate sentence on the appellant was passed in view of the sentence of life imprisonment for the offence under Section 302 of the IPC. Now, this particular case went to the Supreme Court as it was challenged in the Supreme Court in the form of an appeal. So let's understand the judgment of Supreme Court. So the Honorable Supreme Court acquitted the father of the appellant, sentencing 3 years rigorous imprisonment only under Section 201 of the Indian Penal Code. And the court refused to grant any leave to appeal against his conviction under Section 201 of the Indian Penal Code. Further, the court held that maximum sentence which can be passed under Section 201 of Indian Penal Code is deserved by the appellant upon the facts and the circumstances of this case. Thus, they allowed appeal to the extent that they reduced the conviction of the appellant under Section 302 to Section 201 of IPC and sentenced him to undergo 7 years of rigorous imprisonment along with paying a fine of rupees 1,000, and in default of payment of the fine to undergo rigorous imprisonment for a term of 6 months. Now, what is the relevancy of doctrine of res gestae to the present case? So section 6 of the Evidence Act and the doctrine of res gestae is applicable to the present case of Saval Das versus State of Bihar, because the cry of the children from the house when their mother was being killed by their father became a part of the same transaction and therefore fell under section 6 and became admissible as valid evidence. So that is all for today's video. Thank you so much.